Kalispera σας, κυρία και κύριοι. Dear colleagues and friends, good evening. Very welcome to be here in person and also online. After some technical issues, I think we're all together here, so let's start and enjoy this wonderful event. Today is actually a very special day for the Netherlands Institute at Athens and its library, since we are celebrating a new circle of events organized by the library. We couldn't be happier since we begin the library's events with a new series entitled Byzantine Talks NIA, and NIA is the Netherlands Institute of Athens. The series is dedicated to the memory of the late Professor Spyros Troianos, who passed away a few months ago. At this moment, we want to express our very sincere condolences to his wife, Vasiliki Leondaritou Troianou, and we thank her for being here with us tonight. As many of you already know, Professor Spyros Troianos donated to the NIA the core of his book collection, related to Byzantine law and about Byzantine culture. After his generous donation, the Institute decided, amongst other activities, about which our librarian, Sotiria Nikolou, will give us more information, to honor the memory of its donator by establishing a new series of lectures related to the Troianos collection, and you are part of that today here. This is the least we could do, because what he donated to NIA cannot be enough emphasized. I think that is clear. The aim of this new activity is to show the attention that the NIA has invested in the Byzantine collection of this library. And it's unique within the libraries of Athens overall. We have 19 foreign institutes. Very few libraries can say that they have such a significant donation on Byzantine law culture overall in Athens. So we're absolutely thrilled by this presence here. Also, to give the Byzantinologists within Greece and other countries the chance to meet at the NIA, because also that is an important factor. Exchange opinion in the fields and create the environment for dialogue, scientific collaboration between NIA, the international academic community, and the interested audiences in Greece and well beyond, if the technology wants to work. Last but not least, we are very pleased that this first lecture is a collaboration with the Research Center for the History of Greek Law of the Academy of Athens, and we thank the director, Dr. Lydia Papariga-Artemiades, for this and for moderating the lecture.
Dear colleagues and friends, I would like to preface our first scientific meeting of the annual series Byzantine Talks organized by NIA, dedicated to the memory of Spyros Troianos, by an epigram of the best-known neglected thinker of our time, the English philosopher, historian and archaeologist Robin George Collingwood, 1889-1943. No historical problem should be studied without studying the history of historical thought about it. By these words, Robin Collingwood suggested that a historian must reconstruct history by using historical imagination to reenact the thought processes of historical persons based on information and evidence from historical sources. Reenactment of thought refers to the idea that the historian can access not only a thought process similar to that of the historical actor, but the actual thought process itself. So, in addition to being intersectional, our approaches to all legal themes and questions have to be interdisciplinary. Using different kinds of evidence together, laws, customs, literature, material culture, art, architecture, sometimes even human remains, is often necessary to reconstruct a more holistic picture of the Byzantine world. The Byzantines did not separate these from one another, forgetting literature when gazing at art, or ignoring ancient practices and culture when accessing a temple or a text. That lack of conceptual separation should characterize too our attempts to understand the entire legal and social milieu of the Byzantine world. However, not all evidence is created equal. As scholars, we have a responsibility to consider each piece of evidence for what it can offer our understanding and present ancient people and communities fairly as well as accurately. This process requires sensitive engagement with all available evidence. Finally, A fair and accurate research must take under consideration a problem that may be obvious to scholars, but that is too often misunderstood by the broader public. The rules of meaning and interaction are contingent and cannot be usefully transferred from one culture to another, or in one society to another, or even from one situation to another. Through these lenses of approach, we must not be attached to the present, using modern standards to commend or condemn past societies for their attitudes. We must rather emphasize the gap between the past and the present and highlight the problems entailed in relying on antiquity as a precedent for modern policy making. Now I have to hand over to Mrs. Daphne Penna after her legal biography. Dr. Daphne Penna is Assistant Professor in Legal History at the University of Groningen. Penna studied law at the University of Athens in Greece, where she completed her Master in Legal History cum laude at 2003. In the year 2012, she defended and published her thesis on the Byzantine imperial acts to Venice, Pisa, and Genoa, 10th to 12th centuries, a comparative legal study. In 2022, together with Ruth Myrin, she published a source book on Byzantine law, illustrating Byzantine law through the sources. Her research interests lie in Roman and Byzantine law, and especially in their influence on the European legal tradition. She has published extensively on this area. Brill, Cambridge University Press, Palgrave, Macmillan, Taylor and Francis, Dossier Byzantine, Fontes Minores, Forschung sur byzantinische Rechtsgeschichte, byzantinische Zeitschrift, Revue des études byzantines, Subsequent Groningana, etc. Some of the publications deal with comparisons of Byzantine documents to Crusader chapters. Maritime law in the European legal tradition. Byzantine law and the humanists, religious influences in medieval law, slaves in Byzantium, Byzantine legal education, Byzantine legal commentaries, and studies related to the Basilica cum Scholis. She has taught seminars and has given lectures on Byzantine law within universities and research centers in the Netherlands and abroad. For example, universities of Amsterdam, Utrecht, Nijmegen, Leiden, Sorbonne University, the Catholic University of America in Washington, D.C., Dumbarton Oaks, Universities of Oxford, Cambridge, Mainz, Münster, Palermo, Nepros, Athens, Thessaloniki, Edinburgh, Institute of Medieval Research of the Austrian Academy of Sciences, Academy of Athens, Center of Byzantine Studies in Thessaloniki, etc. She has organized 2 roundtables on Byzantine law for the last 2 international congresses of Byzantine studies, in 2016 in Belgrade and in 2022 in Venice, Padua. In 2022, she was honored by the Academy of Athens with an annual award for one of her publications. This is Daphne Penna.
First of all, can you hear me? Yes. The online people are still online, I hope. Ladies and gentlemen, dear Mrs. Troianos, I'm pleased to you. I would like to thank the director and all the people working at the Netherlands Institute in Athens for this invitation to give the first lecture of a new annual Byzantine series of lectures dedicated to the dear memory of Spyros Troianos. I do not have the time here to stress what Professor Troianos means, and will mean for legal historians who deal with Byzantine law, and especially Greek legal historians. Let me just say, and this is not an exaggeration, believe me, that his contribution is so significant in the field of Byzantine law studies that one simply cannot study Byzantine law without consulting the works of Troianos. It was roughly 6 years ago that Professor Troianos contacted me and told me I would like to donate my Byzantine book collection to the Netherlands Institute in Athens, and I would like this to happen before I die. He was very much straightforward in his decisions. Not only this donation took place in time, but Professor Troianos had fortunately the chance to see the collection here and enjoy a symposium that was organized by the Netherlands Institute in Athens and the Department of Legal History of Groningen on the occasion of this donation in June 2022, and here you will see some dear memories of this symposium. The Netherlands Institute in Athens embraced the Troianos book collection right from the beginning. The donation at the NIA took place when Dr. Winfried van der Poel was director at the NIA in 2018 and was set forth in the best ever way under the present director, Professor Andreisberg. The librarian, Mrs. Sotiria Nikolou, registered with great professionalism the approximately 2,000 books of the Troianos collection. But for the people who are here, we'll have a chance to see them in situ. The Deputy Director of the Institute, Dr. Willem Ledeboer, the Secretary of the NIA, Mrs. Amy Macri, the Accountant, Mr. Panagiotis Gasparatos, really all members of the NIA were stand by to help with any practical issues that arose regarding this donation, and I would heartily like to thank all of them for their willingness to give this collection an eminent place at the NIA. I would also like to thank Dr. Marios Standalos from the University of Athens, who helped on many occasions with all kinds of problems of registration and practical matters. The collection is now here, has been registered, and Mrs. Nikolou will tell you more about it in a while. I'm sure that this Byzantine collection at the Netherlands Institute in Athens will become a valuable nursery for future scholars of Byzantine studies. Using this collection, studying the Byzantine sources and promoting Byzantine scholarship is the best way to honor the memory of a dedicated teacher and the father of Byzantine law studies in Greece, Professor Spyros Troianos. And now, ladies and gentlemen, to the Byzantine lecture. What have the Romans ever done for us? Perhaps some of you remember the hilarious scene of Monty Python's comedy film, The Life of Brian. The scene is as follows. During the Roman occupation of Jerusalem, an assembly is held by the independence movement who wants to fight against the Romans. The leader of this movement, who is played by John Cleese, tries to convince the people at the assembly to oppose the Romans. He asks the people, so what have the Romans ever done for us? Expecting obviously to receive a loud negative answer, but to his surprise, someone answers back and says, well, they gave us the aqueducts. Shortly after, another person adds, well, they also gave us roads. And then another person says, sanitation, and the list goes on to the vivid irritation of the leader of the independence movement, who sees his argument being torn into pieces. To this list, ladies and gentlemen, to the list of Roman achievements, we can certainly add Roman law. Indeed, the Romans gave us Roman law. It is true that our society is very different than that of the Romans. For example, Romans used slaves. The concept of family was very different than nowadays. But the basic legal questions remain the same. How do you become an owner of a thing? Is this better? I have to go a bit far from the microphone. How do you become an owner of a thing? How do you lose ownership? What happens when you buy a product, but it proves to have a defect? If you cause damage to someone else's property, are you liable under all circumstances? All these are legal questions that the Romans discussed in detail, and this explains why texts of Roman jurists are inspiring and useful for modern jurists as well. We still can learn from their texts. We can train our legal minds when we read their texts. In fact, modern civil codifications are actually for a great part based on Roman law. I speak of the civil codes, and for the people who are not jurists here, civil law or private law is the law that regulates conflicts between citizens. For example, disputes about a contract of sale or disputes about the acquisition of property. If you look into the modern European civil codes in Greece, in the Netherlands, in Belgium, in Italy, in Germany, and the list goes on, you will see that they are based, the core of the civil codes has been influenced by Roman law, especially in the field of law of obligations and property law. Even before the making of the first national codifications, which emerged in the end of the 18th, beginning of the 19th century, and I have here some examples, the French Civil Code, 1804, the Code of Napoleon, the Austrian Civil Code, 1811, and the German Civil Code, the BGB, in 1900, which, as I said, are influenced on Roman law, but even before that, even before the promulgation of the first national codifications, Roman law still played a significant role in Europe. From the time of the Middle Ages, Roman law was the base of the so-called jus commune, a common system of legal thought that was used in Western Europe from the 11th, 12th centuries up to the first modern codifications of law in the end of the 18th century. But how did Roman law become the jus commune of Europe? We speak about the rediscovery of Roman law in the 11th and 12th century Western Europe, which began in Italy, in Bologna. But the question is, which Roman law was actually rediscovered? How was Roman law transmitted, preserved, explained, and handed over to the West in the Middle Ages? And here, ladies and gentlemen, comes the role of Byzantine law and the Byzantines. As most of you know, Justinian was a Roman emperor in the 6th century AD. In fact, Justinian was an emperor of what we call of the Eastern Roman Empire, and this Eastern Roman Empire is also later known under the term Byzantine Empire or Byzantium. It is good to realize, and I think most of you who are here know this, that the word Byzantine is a conventional term. It was used for the first time in the 16th century to describe the Eastern Roman Empire. The Byzantines, the people to whom we today refer as Byzantines, did not call themselves like that. They referred to themselves as Romans because they were Romans, Romai, and they called their state the Roman Empire because this is what it was, the Basileia Tona Romaium. Justinian was an ambitious emperor who wanted to restore the Imperium Romanum, and to do so he used two means, arms and laws. In the military field, he managed to reconquer a big part of the western part, and you can see here the map. This is the empire during the 6th century when Justinian reconquered a big part of the lost Western Empire. But also in the field of law, he managed to succeed in issuing an impressive legislation in which he codified Roman law. It is necessary to have a closer look at the legislation of Justinian. It consisted of 4 parts. Number 1, the Codex, issued in 534. It included all the imperial laws up to the time of Justinian. The Digest, which proved to be very influential for the history of European private law, as we will see. The Digest was issued in 533 and consisted of fragments of the writings of the Roman jurists who had lived mostly in the 2nd and 3rd century AD. Now, for your information, the Digest is a really huge book. It's 1.5 times the Bible, to give you an idea. And the idea was, Justinian said to the committee, I want you to collect the best opinions of the best Roman jurists into one book. And this is what they did. So the Digest encapsulates the best of the Roman jurisprudence. It's a treasure of legal science. It's a kind of a legal encyclopedia. Then you have the Institutes, issued in 533, which was a legal manual that became also a law. And finally, the Novels, the new laws that were issued after the Codex. Now, most of the parts of Justinian's legislation were issued in Latin. The Codex, the Digest, the Institutes were in Latin, only the Novels were in Greek. And the fact that most of the legislation of Justinian was promulgated in Latin was a problem for his subjects, because dominant language in this empire was Greek. So there you had this majestic legislation, and Justinian was very proud of it, but people couldn't understand it. So, well, perhaps you might ask, then why did he issue it in Latin in the first place? There were 2 good reasons. Number 1, it was practical. Most of these texts were already written in Latin. I told you the Digest, it consisted of opinions of Roman jurists, well, they had written in Latin. So it was practical, but there was also an ideological reason. Justinian wanted to restore this Imperium Romanum, the Roman Empire, so it fitted his vision. Anyway, the problem was people couldn't understand it. So what happened was, shortly after the promulgation of Justinian's legislation, jurists started to translate part of Justinian's legislation into Greek. And when I say jurists, I mean the law professors of the time of Justinian. They started to summarize the digest, for example, in Greek, or the codex. And antecessors is a word that perhaps you've seen. Antecessor means a law professor at the time of Justinian. The term means literally, it comes from the military field. It means the man leading the way, because it was used to describe the officer who walked in front of the army in order to investigate whether the ground was safe so the other people could come. So the law professor, and I think any professor, has this task to walk in front and open up the path of knowledge to his students. So the antecessors of the law professors at the time of Justinian had to tackle the language problem, teaching Latin legislation to mostly Greek-speaking pupils. And they developed a special teaching method, which was thoroughly studied by the Dutch professor Herman Jan Scheltema. And that is actually the reason that Troianos donated his book collection here, because of the work that's been done in Groningen in the field of Byzantine studies and the friendship that Troianos had with Professor Scheltema. What do you do as a teacher when you have to teach a material that is another language? Well, you translate it in your own language. This is what they did. They started translating, adapting Justinian's Latin legislation in Greek to help the students. And this transition from Latin into Greek marks the birth of Byzantine law, as Professor Bernard Stolte has explained in more of his writings. So that there's no misunderstanding, this doesn't mean that Greek was not used before the 6th century in legal documents. It was used, but if you really want to place a date, and many historians love dates, then I think it's fair to say that the work of the antecessors played an important role in creating Byzantine law. Simply said, what is Byzantine law? It's just Roman law, but in Greek. At least this is how it began. Roman law was never forgotten in Byzantium. In other words, Roman law was present throughout the whole period of the Byzantine Empire, and even beyond that. This is what happened in the East. What happened now in the West? After Justinian, Roman law was forgotten in the West. Generally speaking, from the 6th century up to the 11th century, or beginning of the 12th, there's more or less a gap of Roman law in the West. And when I mean Roman law was forgotten, I mean the digest was forgotten. And as I explained, the digest was the most sophisticated text. It consisted of the opinions of the Roman jurists. And all this changed suddenly in the 11th, 12th century. In that period, Roman law was suddenly rediscovered in Italy, in Bologna. And from Bologna, Roman law was very fast spread throughout Italy and Europe. And when I say Roman law was rediscovered, I have to clarify it was the digest that was rediscovered. And here you see a manuscript, a photo of the manuscript of the digest, a 6th century manuscript of the digest preserved today in Florence. So no, this manuscript has a name, the Littera Florentina. And according to the sources, it was Irnerius, a teacher of liberal arts, who started first to use the digest in class at the end of the 11th, beginning of the 12th century. And Irnerius and other scholars of this period and the next century started writing comments in the margins. And you can see this in the photo. What you see in the center is a part of the codex of the digest, and all these comments around the document are what we call glosse, annotations, like track changes, but all over the place. Which these glossators, and by the way, that's why the school that Irnerius founded is called the School of the Glossators. It takes its name from the way they expanded the text by writing these glosse annotations in the margins of the text. Now, why the rediscovery of Roman law began then, 11th, 12th century, and there, Italy, we do not know. A modern scholar, Kenneth Pennington, Catholic University of America, speaks of the Big Bang of Roman law in the Middle Ages. There are different theories, and I won't get into that right now. The fact is that at that point, there was a need for a law that could solve more difficult legal problems. The rise of commerce, of Italian cities, for example, and the digest was a legal text in which you could find solutions to complicated legal problems. So the time was right for the digest. Again, and I would like to emphasize on this, and I think that's the most important, the language is important. As I mentioned, Justinian issued most of his legislation in Latin. At his time, it was a problem, as I told you, because people couldn't understand it, so they had to translate it in Greek. But the fact that he had published in Latin his legislation proved to be beneficial later on for the western part of Europe, because in the 11th and 12th century, Latin was like English of today. Most of the people could understand it. And since most of the legislation of Justinian was written in Latin, it was possible for the people of the Middle Ages to read it, use it, and apply it. In other words, if Justinian had issued his legislation in Greek, nobody would have cared in the Middle Ages, and we would have had another story to tell for European private law. In fact, the saying in the Middle Ages was Greca non legundur, which means Greek is not read. So if a copyist saw a Greek document, he just dismissed it. It was thus fortunate for the West and for the fate of Roman law that the Byzantine Emperor Justinian had issued his legislation in Latin. So to go back to the question, what have the Romans ever given us? Roman law indeed, but how? Through the Byzantines, via Justinian, that is. The Roman law that was rediscovered in medieval Italy and Rome, the Roman law that was rediscovered in Bologna and became later the part of jus commune in Europe, part of the common legal thought in Europe, and influenced later on even modern codification in Europe, is the Roman law that Byzantine Emperor Justinian had codified. And there are some scholars who have characterized Justinian as the legislator of Europe. By the way, the term that is used for the legislation of Justinian is the term corpus juris civilis, which means the body of civil law. And if you open up any book on legal history or history of law in Europe, you will see a chapter, or at least a section, dedicated to the legislation of Justinian, or at least the corpus juris. What you will not see is that Justinian was an emperor of the Eastern Roman Empire, the Byzantine Empire. And what you will also not see in a book about the history of law in Europe is what happened to Roman law in the East. There are a few exceptions of books, and I exclude here the Greek publications. My criticism goes more to English publications, which are the ones that are being broadly read. And as I have explained, and I'm summing it up here, in the West there's a gap of Roman law from the 6th century up to the 11th century, but in the East there's no gap. There's continuity of Roman law. Roman law is uninterrupted. And actually, even after the end of the Roman Empire, Byzantine law still exists. I can understand that most of the scholars in their publications are interested in the fate of Roman law in the West. However, since most of these publications refer to the history of law in Europe, it is, I think, unfair to wipe out the history of Roman law in a big part of Europe, southeastern Europe, where the Byzantine Empire existed for more than 1,000 years. Moreover, I think that it's especially unfair to do that, because as I have explained, in that part of Europe, Roman law was always present. In any way, by dismissing the fate of Roman law in the East, you say half of the story to your audience, and in fact, you leave the juicy part outside, I think. And yes, I can understand that modern scholars in their publications are interested in the development of Western law, of Roman law in the West. I mean, that's their focus. And I do not expect an elaborate story of what happened to Roman law in the East, but at least some reference could be made so that the audience knows the whole story. In fact, in several authoritative books, I think that there are misunderstandings, or scholars do not know the importance of Roman law in the East and the value of Roman Byzantine law in general in the European legal tradition. I'll give you one example. It's an authoritative book. It's a book by an excellent scholar. We use it in Groningen for one of the classes. The book is by James Gordley, as I said, an excellent scholar, or an author of a series of important books. The book is called The Jurist's Critical History, and the author examines in that book the work of Western jurists from ancient Rome to the present. In the first chapter, the author mentions, and I have it on the PowerPoint, in the 6th century, the Emperor Justinian ordered a compilation of legal texts to be made that later became known as the Corpus Juris Civilis. The Corpus Juris Civilis fell out of use in the Eastern Roman Empire. Classical Roman law was forgotten, not to be revived until the Middle Ages, and then on the basis of a single manuscript copy known as the Pisana or Fiorentina. I think that's not true. At least half of it is not true, but I have underlined it's not true. Roman law was not forgotten in the Eastern Roman Empire. The Corpus Juris did not fall out of use in Byzantium. It did fall out of use in the West, but not in the East. But I wonder how many scholars know this. This other half story of the Corpus Juris in the East, in Byzantium that is. I will only mention one Byzantine work here that reflects the Corpus Juris in the best way in Byzantium. As I said, Justinian's legislation was issued in Latin. The law professors at his time started translating this legislation in Greek, and gradually, with the due of time, you had several Greek versions of all parts of Justinian's legislation. There were Greek versions of the Digest, the Codex, there were really too many. So at some point, at the end of the 9th century, the emperors at that time, they wanted to clear out, they call it the purge of laws, they wanted an anakatharsis των νόμων, they wanted to clear out the mess, and the result were the so-called Basilica. The Basilica laws, τα βασιλικά νόμιμα, is a massive legal compilation, consists of 60 books to give you an idea, which was issued around 900 during the reign of Leo VI the Wise, the Byzantine emperor, which you see there in the mosaic. And it consists of all parts of Justinian's legislation, but then in Greek. So it renders Justinianic law, but in Greek. The compilers made one big text, which consisted of all parts of Justinian's legislation, but then in Greek. The compilers of the Basilica did not translate at that point in Greek the Digest or the Codex. They didn't do that because they had versions that they could use, and I think they did what anyone will do. They did, well, it's a natural inclination, we are all lazy. Why would you translate the text if you already have a translation? This is what they did. I think most of us would have done the same. So they used Greek versions that they had, and they placed them in this Basilica. So simply said, the Basilica is a Corpus Juris Civilis, but then in Greek. And for the people who are here, we are going to visit the book collection, and it's really, Troianos' collection has all of the volumes of the Basilica edition, which are rather rare, and we'll have an opportunity to say something more about that for people who are here on stage. This is the Basilica text, but later, from the 10th century onwards, comments were added to the text, just as the glossa, the same happened here. Scholia were added to the text of the Basilica, and these scholia, these comments, are distinguished into two categories. You have the old scholia, which were actually comments of the antecessors, the law professors of the 6th century, which were added to the Basilica because they helped the interpretation of the text, because as I said, the Basilica is Justinianic law, but then in Greek. So these scholia date from the 6th century. But later on, in the middle of the 11th century, a law school was founded in Constantinople, or better said, the Byzantine emperor at that time appointed an intellectual of the time, Ioannis Xyphilinos, as head of the law school in Constantinople. He became the so-called nomophylax, the director, the guardian of the laws, the director of the law school there. And Xyphilinos and other jurists of the 11th and 12th century also wrote scholia around the text of the Basilica, and these scholia are known as the new Basilica scholia to distinguish them from the old. So there are two layers. And I will not get into the whole discussion of the old and new Basilica scholia, but I can tell you that the new Basilica scholia can, in some cases, tell us something about the Byzantine legal thought and practice of the 11th and 12th century. And this is especially interesting because this is the period in which Roman law was rediscovered in the West. And whereas the glosse, the annotations made by Western legal scholars, have been studied in detail by modern scholars, very few scholars occupy themselves with the Byzantine gloss. And you have an example of Byzantine glosses here. What you see there on the left is part of the Basilica text, and the two columns on the right are scholia, which are made in text by Byzantine jurists. To be more precise, most of the modern scholars of legal history do not even know that Byzantine jurists also wrote scholia in the Corpus Juris. And in fact, if we take a look into the Byzantine legal tradition, we can see that the Byzantine jurists are closer to the Roman text, since Roman law was never interrupted in Byzantium. And a good example are the old Basilica scholia, which I refer to. They derive from the teaching of the antecessors, from the law professors at the time of Justinian. And some of these antecessors, some of these of the law professors, were actually members of the drafting committees of the Digest, the Codex. So they really knew Roman law. Actually, the new Roman law, even before it was codified by Justinian, So their scholia can help us better understand even classical Roman law up to some extent. This is something that's been stressed by Fritz Brandsma, Professor of Roman law at the University of Groningen, and has been highlighted by more scholars as well, Hilke de Jong and myself among others. When examining Roman law in the Middle Ages, a known scholar spoke of a ghost story. Other scholars have spoken of the many lives of Roman law, and I have a cat there. If that's the case with Roman law, then Byzantine law is not even a ghost story. Byzantine law, ladies and gentlemen, does not even have one life, at least for the majority of modern scholars. In fact, to tell the sad truth, Byzantine law is essentially bypassed in modern books that refer to history of law in Europe, apart from the Greek editions. There are rare to non-existent references to Byzantine law in modern foreign language books on European history of law, mainly English again. Just as Byzantine history was neglected for a long period of time from the history of Europe, the same goes for Byzantine law. I think it makes sense to include Byzantine law in modern publications of the history of European law, not just because it was, after all, a Byzantine emperor who gave us Roman law, Justinian, but also because in Byzantium, as I explained, there was always a continuation of Roman law. Furthermore, I think that there's a need to examine the legal traditions, Western and Eastern, comparatively. Again, I will say it in a simple way. All historians agree that Justinian's Corpus Juris is the basis of our modern civil codes. It makes sense to see how this Corpus Juris was developed in the West, how was it developed in the East, and then compare both. There are two good reasons to do that. Number one, by studying comparatively the Western and Eastern legal traditions, perhaps we will be able to get rid of some misunderstandings concerning Byzantine law or Byzantium in general. And I'll give just one example, very brief. Very recently, during the Spring Symposium of Byzantine Studies last April at the University of Kent in Canterbury, I made a comparison between Cesare Beccaria, a very known author of the Enlightenment and father of modern criminal law on one hand, and the Byzantine Emperor Leo VI the Wise. Beccaria was the first who spoke about fair punishment, emphasizing the proportionality between crime and punishment. But if you have a look at the laws of Leo, which is end of the 9th century, you will be surprised to see that Leo had also addressed the same issues in criminal law and had, for example, stated in one of his laws, his novels, and I cite it, I have it on the PowerPoint, he says, fair punishment exists when the guilty is subjected to a punishment proportionate to the gravity of this offense. As I had mentioned at the Spring Symposium, I think that modern jurists will be rather surprised to find out that these lines actually derive from a Byzantine emperor from the late 9th century. Byzantium is, after all, still considered, at least by some, a decadent and dark age theocratic society. And since we are talking about the Byzantine Emperor Leo VI the Wise, let me say that it was Professor Spyros Troianos who studied the laws, the novels of Leo VI par excellence, and he made them broadly known to a larger public. Number two, why should we compare Western to Eastern legal traditions? I think it helps to reveal the common legal heritage of Europe. I think there's a greater common ground than people think or we think. Several times I've seen in my research an interaction and mutual influence between Western and Eastern legal tradition. Byzantium was not cut off, especially in the 11th, 12th century with the growth of the Italian city-states, crusades. There are definitely connections and interactions between Byzantium and the West in various areas. I would like to bring a last example of a valuable Byzantine legal source which proved to be influential not only in southeastern part of Europe but also in the West, and that's something not so known, the influence in the West. What I will say is based for a big part on the research of a great Greek legal historian and another dear teacher, Professor Konstantinos Pitsakis. For my Greek colleagues who are listening to this lecture, I think you already have a clue about which source I'm going to talk about. It's the Examplus. The Examplus is a work dated from the middle of the 14th century, which was written by Konstantinos Armenopoulos, a judge in Thessaloniki. The Examplus is also known as the Prochiron Nomo tu Armenopoulou, or in Latin, it was translated in Latin, Promptuarium Juris, etc. Aim of Armenopoulos was to create a legal handbook, easy to use in legal practice. This is also implied in the Greek title prochironomon, since the word prochiros means something at hand, in this case an easy handbook of laws. Because of its simplicity, the Exabiblos became an influential text in the eastern part of Europe. It was rendered many times in modern Greek, it was reprinted several times in Greece, and it was used in legal practice up to the promulgation of the first Greek civil code in 1946. It has also been translated into Slavic languages, was spread throughout the Balkan region, but also in Western Europe, and that's not so known. It received much attention, as it is proven by the number of critical editions and translations. There are 13 editions of the Exabiblos in the West in original or in Latin or in German translation. Perhaps the most surprising testimony of the Exabiblos in the intellectual life of the West is the one that Pitsakis has revealed. The reference to the Exabiblos by Jean Racine. Racine was one of the most known French dramatists of the 17th century. In 1668, he wrote the comedy Les Plaideurs, The Litigants. The plot of this play is an adaptation of Aristophanes' Wasps, and for the Greeks of my generation, perhaps you see the comic there. I was growing up with these comics. Perhaps some of you recognize this. Protagonist in Racine's comedy was a judge named Danton, who was addicted to courtroom life and was obsessed with judging cases. His son, Leandre, in order to please his father's obsession, sets up a fake court at his house so his father can judge some domestic cases. A case is brought before the judge Danton. The defendant is a dog who was brought to trial because he ate an appetizing capon, a special kind of chicken. His lawyer, Lantimé, in his speech before the domestic court, supports his legal arguments by referring to the most famous names he can think of in the field of law. He refers to Aristotle, to Jacques Cousat, the known legal humanist, and to our Armenopoulos. And I have here the fragment on the slide. So the lawyer says, he refers to Aristotle, but I've highlighted in red, and then says, Danton, to the point, Le Grand Jacques, that's the Jacques Cousat, and at the end, Armenopoulos in his front. This proves a bit how known the Exabiblos was in the French society at that time, and I have another testimony for how known the Exabiblos was in Germany, and that's the last item. There are interesting testimonies covering the use of the Exabiblos in Germany. The Exabiblos was translated into German by Justinus Gröbler and was published in Frankfurt in 1564 and republished in 1566 and 1576. Gröbler, who made the translation into German, describes in the preface that he's made this German translation because of the common benefit, the gemeinen Nutzen, and for the ones that are interested in the text from the jurists, the judges, the officers, and others whose Latin was not so good in order to help them. And there's another interesting testimony concerning the German translation of the Exabiblos and the use of the Exabiblos in Germany. In 1832, the Bavarian Prince Otto was appointed King of Greece by the three great powers. Because Otto was a minor, a regency of 3 men was also appointed to govern until Otto reached adulthood. One of the regency members was Georg Ludwig von Maurer. Von Maurer was responsible for justice, ecclesiastical, and education issues of the new Greek state. He published a book referring to the Greek public, ecclesiastical, and private affairs before the Greek War of Independence and up to the first years of his regency, and in that book he referred to customs and laws in Greece, and inevitably he referred to the Exabiblos. And von Maurer says that he owned a copy of the German translation, and he also made the comment that there were 3 editions of this work within 12 years in Germany, which meant, according to him, that it must have been useful for the law students in Germany, and presumably it must have been used in German courts as well, since in the preface of the German translation of the Exabiblos, it is mentioned that it is made for the judges, the officers, the jurists, as we saw. So it seems that the Exabiblos was used in German legal practice. And at this point, I'd like to bring an hypothesis which might seem far-stretching to some. What is remarkable and has drawn the attention of a few scholars is the actual structure of the legal material by Armenopoulos. The Byzantine judge moves away from the threefold Roman division of persons, things, actions, and he divides civil law into the following 5 parts. Number 1, general part, and then follow the specific part. So this is the first time that this happens. We have a general part, and then we move into the particular subjects. And if we look into modern civil codes, this is the standard thing. Most of the modern codes have a general part, but that's not Roman. The first time we see this in the West is in the German civil code in 1900, the Bürgerliches Gesetzbuch. There you see first an allgemeine Teil, a general part, and then dividing, then moving into specific subjects. And scholars nowadays say that this structure in the German civil codes is based on the influence of the late natural law lawyers who flourished in Germany in the 17th and 18th century, Uffendorf, Thomasius, Wolf, some names. But my hypothesis is, and it's only a hypothesis at this point, given the fact that the Hexabiblos was known in German legal circles, I wonder whether our humble Byzantine Armenopoulos perhaps played a role in this development of the structure of the material of civil law in Germany. This is just a hypothesis, but it shows the potential usefulness of comparing the Western to the Eastern legal tradition. And I come to the conclusions. Nowadays, there's really no dialogue between scholars who study the Western legal tradition and scholars who study the Byzantine legal tradition, with a very few exceptions. Personally, I think it's a fascinating field, and I hope I've convinced you that the comparative study of the Western and Eastern legal traditions can reveal a lot about the common legal heritage of Europe. Professor Spyros Troianos devoted the greatest part of his research activity to Byzantine law. It was he who established Byzantine law as an independently taught branch of the history of Greek law at the University of Athens. Thanks to him, Greek legal historians were able to cooperate in the field of Byzantine law with foreign scholars mainly from Germany, Austria, and the Netherlands. It was he who focused in both finding and publishing unpublished or insufficiently published Byzantine legal texts, as well as organizing and supporting research in his field. And I will only mention the memorable collaboration of Troianos with a professor of civil and Roman law at the University of Frankfurt am Main and dear friend of his, Dieter Simon, which began in 1974 and led to the implementation of a research program aimed at the study and critical edition of Byzantine legal sources of both secular and ecclesiastical origin, and had significant results. We, the younger generations of legal historians, can now rely on the valuable work of Troianos and continue to explore Byzantine law and study in a comparative way to the Western legal tradition. To conclude, ladies and gentlemen, the study of Byzantine law is also a study of European law. This is something that most of the legal historians and more historians forget. And more generally, the study of Byzantium is not only a study of the history of the Eastern Roman Empire, it is also a study of European history. Thank you.
Thanks a lot, Dr. Daphne Penna, for this very well organized and introductory speech to all the themes of Byzantine law. And now we can hear your questions, please. Notices, whatever you have to say on this very well speech from Dr. Daphne Penna. Please. Yes? Mrs. Eleftheria Papariga.
Thank you very much. Θα δοκιμάσω χωρίς, γιατί αυτό δεν είναι πολύ.
Γιατί αλλιώς δεν ακούγεται στο Zoom, πρέπει να μιλήσετε από το μικρόφωνο.
Μπορείτε να το κρατάτε σε αυτό.
Κάπως πρόκειται να το
Όπως είναι, είναι αδειγμένο. Είναι αδειγμένο, ναι.
Τώρα είναι αυτό. Thank you very much. It was very, very interesting. It was very interesting above all for the younger Jewish historians of law. And that's the meaning, because Spyros Troianos was first of all teacher, professor, daskalos, and it is very important that all these lessons who are being engaged to this memory have a didactic purpose. I have no question, but I would like to express a thought. Are you sure, or is it possible that the difference about the continuity of the Roman law in the East Empire was not due to a lack of knowledge, but was a political view? It is the old problem, what is Europe and what is European tradition? And we know very well that the Byzantine Empire is not seen as a tie of the European tradition. Perhaps not for all, but for many. Politicals and also scientists. But I must tell something else too, that the Greek science and the Greek history and the Greek people and the Greek professors and teachers made a mistake that they discovered Byzantium very late or too late, and unfortunately not always in the right way. They give the wrong image. This image that makes many people, many young people, to avoid this the study of this period as history, as law, and sometimes the art have a better luck, but not always. So I think that it is time, and it is very good to do that. Let's see that as a beginning for an effort to rebuild Byzantium as the piece of Europe. Thank you very much.
I totally agree with Professor Troianos, and that's the point, but also the aspect that Professor Troianos highlighted here, the Greek attitude of teaching Byzantium as well. Yeah. As I said, from my experience, I find in many occasions an interaction between both traditions, but the fact is, most of us are not here Greek audience, but as I said, basic English books do not even refer to it, and I think they don't know. They don't do it deliberately. They just don't know about it.
Maybe they don't know because there is always the problem of Greek language.
Yes,
because for the Eastern Roman Empire, there are a lot of essays written and on specialized themes, but they are written in Greek. So this is a problem. That's why the Westerns can't appreciate this analysis on these themes.
We hope that this annual lecture will help. This annual lecture to connect.
This is our aim here. This is our aim here to make closer the contacts between the Western legal tradition and the Eastern legal tradition, and to make in touch the researchers from different fields, not only legal researchers, but also Byzantine archaeologists and other scientists, so as to have better results. And I think that this is an aim for continuity on this field. Okay, another question, please.
maybe in addition, this would also be a very, very good reason why ancient Greek, which is this would also be a very good reason why I feel that ancient Greek, which is now diminished or even abolished in Western schools and universities in Western Europe, can be revived, because if we don't read the original texts anymore, then we're in trouble, of course. And I'm not just talking about ancient Greek, but Greek as a language in general, so classic Greek and any Greek that is related to texts. The question I had, Daphne, I should clarify, I'm the GP prehistorian, is the following. So you explained, and I learned a lot here tonight, you explained that Western Roman law stopped in the 6th century and was revived 11th, 12th century, and this law continued, let's say, in Eastern Europe. Then there was the glossa from the glossae, so the additions, let's say, to law in the West, and then the scholia in the East. There's actually two questions. One question is, do the glossae compare, although they're earlier, of course, to the scholia in terms of content in West versus East? And the other question I have is, how is it actually possible, and maybe this is a question you can answer, but just I wonder, that this law disappears in the West for 6 centuries, even though we know very well that there is a continuation of economic transactions, of interaction between regions, archaeologically attested and historically attested. What is going on that this disappears? Well, I think law is very often linked to economic being, economic transactions, and so on.
Okay, to your first question, yes. I don't know if I explained it. You have, here's a slide. Yes, the glossae, the annotations that Western jurists made was on the corpus juris, on the codex, on the digest. The glossae that the Byzantine jurists made is also the same material, so that's why it makes sense to compare them. And in fact, I don't know if I couldn't elaborate, but the Byzantine tradition has two kinds of scholia. Scholia which go back to the 6th century, which means that the law professors really know what they're talking about, since they took part in the codification of Justinian. But also 11th and 12th Byzantine jurists, Philinos, Theodoritis, there are some names. And actually, if you compare some of the scholia of the 11th and 12th century Byzantine jurists, you would be surprised with how sophisticated they are. And it makes, they have the same material, so it makes sense to compare. You can go back to the digest and say, okay, this part, do we have glossae, do we have scholia, and then make a very nice comparison. But you have to know Greek, and you have to know Latin. But okay, it can reveal, as I said, a common, legal ground. To your second question, I have of course simplified things, but indeed, from the 6th century up to the 11th, there's a gap of Roman law in the West. When I mean Roman law, digest, because they did use some Roman texts. We speak of the vulgar Roman law in this period, which is a bit of, it's not the classical Roman law. On why this happened, we do not know. They lost the manuscripts. Probably the society was rather agrarian. They were not so, there was not an enormous need to have, as I said, a legal text that will solve everything. But 11th and 12th century, this changes. First of all, they found the manuscript of the digest in stages, and then they had all these legal problems because of the new economic activities that took place, and it all fitted. But why this happened? There's still, I said, there's the big bang of Middle Ages. There's still different theories on why this happened then, suddenly, and of course Italy is not so strange, because Italy has had always great relations with Byzantium, and not to mention southern Italy, which is another issue. Thank you.
Okay. There is a question on Zoom by Mr. Nikolou Valente, and he says, I have a question more on the actual legal system. As we know, the European Union is a completely legal construction, and jurists were influenced by the Roman law. So do we have some example that proves that some elements were in fact more Byzantine, if we can say something like that, Byzantine law being Roman law?
If I knew this
I will have made a book. And I don't know, that's something to find out. I don't know, I can't think of something. I have to think about it. And I have to study the material. It's a nice issue. I only, on the basis of the research that Professor Spyros has done on the examples, I have this hypothesis of whether the examples was used for the structure, but I cannot prove it yet. I'm optimistic. I have to find German jurisprudence, German testimonies, but maybe there. But who knows? I don't know. It's difficult to say.
He seems to be happy with that.
But of course, both traditions are based on the
I think it's very logical that there is not a parthenogenesis in the themes, in most of the themes, and as well as this comparison between the gloss and the Byzantine scholia concern. Think that there is an old essay written by Prince Haim, who proves that there is a connection. As for the mythology of the scholia, the mythology is the same in Glosse and the Byzantine scholia, and he has a whole analysis about this matter.
I think it's also the same. They are jurists and they are describing legal texts. It's just that it's interesting to see what do they say about one subject and what do the other sides say. And I would say there are also some studies made about Bologna, rediscovery of Roman Bologna and the foundation of the law school in Constantinople, and whether there was a link, but it's still, I think that's not proved yet, as far as I know. But okay.
Have also in mind that during the 4th and the 5th centuries, there was also the legal schools of Beirut and Alexandria,
Yes.
where there was a whole system of education, of legal education.
Of course, and Beirut was most known for.
So there is, we can see that there is a continuity in all these things. Another question, please. This is.
Thank you for the most attractive lecture I've heard about Byzantine law, and good luck with all the hypotheses and everything. The comment and question I have to make has mostly to do with Byzantine culture in the 6th century and the personality of Justinian. Because quite often we hear that Justinian was the last emperor who spoke Latin as a native language. And we know that he was born in Justiniana Prima in North Macedonia, where definitely Latin was spoken. And then we have him ordering this compilation of all these laws, but they're all done in Latin. However, the names are in Greek. Could it be that actually the Corpus Juris Civilis was destined also to be translated in Greek? And I'm thinking about this because if there was really a need for the jurists in 6th century Constantinople to read law only in Latin, on the other hand, we have Paul Silentiarius, who writes the description of Saint Sophia, and it is 1029 verses in very beautiful Greek. And this poem was definitely to be recited in the church for all the high society, and they would definitely have the ability to understand this high level of Greek. So that's why, it came as a question to me whether this compilation was actually made because it has nothing that is contemporary to Justinian as a new legislation. I mean, is this right? I mean, this coming from a person who has no idea about.
You mean the legislation of Justinian? Yeah. As I said, most of it is based on laws that already exist, which most of them are in Latin. There are some Greek. The digest for it was they wrote, so it was practical, as I said.
Yes.
I don't know. There are colleagues here who have experienced, of course, whether there was a plan to translate it in Greek.
Because it's just a hypothesis that it just occurred to me now.
Yeah.
Because it just troubles me that they put all these Latin texts together in a fairly short period of time.
Yeah.
Okay. So it looks to me as if they were trying, you know, to bring everything together for later use.
I think that I have it is that, you know, at the time of Justinian, there were so many laws. There were so many, I have to explain that opinions of Roman jurists at that time, you could use them in court and win a case. At some point, they had this, there were not laws, but the legal advice had become, you know, if you use an opinion, you could win the case. So you had so many laws, you had so many legal opinions. So you didn't know what was the applicable laws. So that's why he did it. And that's why there's a system in his legislation. You have the codex, all laws, the digest, and legal opinions. So I think he tried to clear out the mess. I think that's something that you see in Byzantine law. You try to clear out the mess, but then you make a bit of a mess because it's so big what you make. So people start making summaries, and we are lazy. So then comes another emperor who wants to another huge of laws, and then it's too big. So you have to make again summaries, and it goes like this. So to your question, I think, as you said, it made sense to have it in Latin. Yeah.
I have a question. First of all, thank you. No, it's not. I have a lot of noise. That helps. Okay. Can everybody hear me?
Yes.
Okay. First of all, thank you for an extraordinarily interesting presentation. I think that we don't know enough about Byzantine anything, culture, religion, law, whatever. But tonight is
a night,
and it's a beautiful tribute, I think, to Professor Troianos. He would have been happy, I think. I mean, I didn't know him, but I think that he did a beautiful job on the presentation. So my question is this. You talked a lot about the influence in the East, the law, the Eastern law, the West, the law of the West. When we talk about the West, you're talking mostly about Germany, Italy, France, Netherlands.
Mm-hmm.
Is England included in that? UK?
No.
No.
Because
Okay.
the UK has different.
This is a different law.
It makes it complicated only with the Common Law, which has nothing to do with the use common law.
Okay.
But they didn't have Roman, there's no Roman law except in Scotland.
Because my next question is there a book, you talk about texts in Latin and Greek. Is there a book in English about Byzantine law?
Yeah.
You published a book? Okay, thank you.
Yeah.
That's it, thank you.
There are some people who don't know.
Mrs. No? Okay.
So, thank you, Daphne, for your very interesting lesson, and especially to the suggestion concerning the translation of the Academy of Athens. Because I think that we have to consider a very north-side channel of transmigration of Byzantine sources, even legal probably, from the east to the west, possibly connected with the religious reform, probably with the Protestant, in order to avoid the cultural power of the papacy. Because we have to remember that when we speak about Roman law in this period, Renaissance science especially, we speak about the Roman culture of the papacy. And I have a question for you, because, for example, we know that in the 15th century in Prague, during the Hussite Revolution, we had an attempt of a connection between the Hussite culture, religious revolution and so on, and Constantinople, in order to avoid the Roman papacy and that kind of Roman culture. And also during the Protestant reform, for example, Melanchthon is the most important example. We have the same attempt in order to know, in order to consult the Eastern Byzantine culture or the memory of that culture. So my question is this: we know that through this channel we had the passage of Byzantine sources connected with literature, with history. We are sure about this because we have the creation of Protestant historiography connected, especially connected with the Byzantine sources. But do you think, and I don't know, this is an evidence, the translation of the examples in Germany, do you think that also this kind of transmigration, this kind of channel is interesting also the legal sources? In this way, before, a lot of time before the great publication of sources during the 19th century, especially. Because it's very interesting, very strange, no? Because in this German Renaissance, Protestant German Renaissance, Greek good. There is an interest in order to avoid the Roman culture represented by the papacy.
Yeah, I don't know, maybe.
This is a really not studied channel of
but it's not studied, you're right.
Very interesting.
Yeah.
Because we have the example of the example, because in German.
And the example was also in Latin. It was, as I told you, I think the reference that text has found in Racine is extraordinary, I find it, because Racine display was played at Versailles, and you have to understand that Racine, he was not a jurist, he wanted to find out what are the sources, Aristotle, Jacques Pujard, and Avranopoulos. For me, it's really extraordinary that he mentions that. So that's a very nice testimony.
The translation is in Latin, not in German.
Yes, Latin. So there are translations of examples in Latin and in German, three publications. But yes, thank you.
But there is also a very interesting book of this.
Yes.
This Troianos, Hans Troianos. Who has all these books that there is all this connection. The people who were working all these years when did the Renaissance, the Western Renaissance. Yes. Okay.
Thank you. First, I'm very happy to hear you again 1 month ago. I heard you in Kent University. My question is somehow linked to the last question, but the interpretation may be different. If Byzantine law was firstly translated into Germany, maybe that's just because at that time Germany was under the rule of so-called Holy Roman Empire. That is why they are more interested in Byzantine law as part of the tradition of Roman law. Earlier, we just talked about the language question, but I think ancient Greek language was a common language between scholars in Western Europe. We know that in 16th century, especially for the humanists in Italy, they can even wrote Greek poem or Greek history. There's not problem. But earlier in 15th century, it seems that in Italy, even if the Italian human race was very good at ancient Greek, but they didn't translate it Byzantine law. Maybe that's because they are more interested in ancient Greek heritage. For example, Ficino translated Plato and Plotinus. So I'd like to know what do you think? Why it was later or only in Germany they started to translate the Byzantine law?
So, it's not in Germany. I said that in Germany the example was translated into German, but France was one of the first countries where we have the first critical editions of Byzantine legal texts as well, and then Germany came. So
Yes, but not in Italy.
Yeah, well, humanism began in Italy, and then legal humanism, well, it began in Italy, but legal humanism, the most gallicus, flourished in France. Jacques Poujat and Bourges, and they were interested in editing Byzantine legal works. But this can be the subject of another lecture, because I think, but you're right, and it's again good to see this tradition, and it's interesting to see. I only talk about the examples, you know, but there are more Byzantine legal texts to see where they're translated, in which language, in which countries, and Italy has always a special place, especially, I didn't refer to southern Italy, that's a special area where Byzantine law was always somehow present. But I just give some hints here, and I think now we can move to say a few words about the library and the collection of Troianos, and the people who are here, we can have a look at the book. So,
yes. Okay, so I have to present Mrs. Nikolou. Thank you very much for the very nice discussion. Now, Mrs. Sotiria Nikolou holds a bachelor degree from the Department of Library Science and Information Systems, Faculty of Management and Economics at National Technological Institute of Athens. Currently, she is a postgraduate student of Cultural Organization Management at the Hellenic Open University. She previously worked in several libraries, such as National Library of Greece, Academic Libraries of National and Attendees University of Athens, Municipal Libraries in Attica, and in other regions in Greece. She has been awarded with the Librarian Award for the year 2013 by the Department of International Board on Books for Young People for her work at the Children's Library section and for promoting the love of reading. In the Institute, some of her main responsibilities are the managing and processing of the library's material according to international standards, cataloging rules, AACR2, indexing and classification. Also, she provides assistance to the patrons of the NIA's library, and she is in charge of the cataloging and classification of the Byzantine-related publications that came to the NIA thanks to the generous donation of Professor Spyros Troianos. Mrs. Nikolou, we hear you now.
So good evening from me too. I hope you hear me, because as a librarian I don't speak too loud. So welcome to the Netherlands Institute at Athens, and thank you all for being here today. Is it better?
Micro.
Okay. I hope it's better now.
Yes.
Okay. As our director said in the beginning, it is a really important day for us, since the library starts a new chapter which includes several events. And we're really happy that our first event is related with the Troianos collection, since the specific collection led to the expansion of the library with a new section. As Daphne Penna said before, a cooperation with Dutch academics led Professor Troianos to the decision to donate the core of his book collection to the Institute. So now let's see the journey of the donation. In 2018, the first conversations began between the Institute and the profession in relation to the collection. Due to the limited space, a specific number of books was selected. It was then decided to build new bookcases, which was made possible with the help of the association Groningen's Recti Stories Fund, which donated an amount of money for this purpose. In 2019, the contract regarding the donation was signed. The document also described the reason for which Professor Troianos decided to donate his book collection to the Institute. In the left picture are the bookcases that were built for the specific collection, and in the right picture you can see the books that were transferred to the Institute, so you can see their many. The collection consists of approximately 2,000 items, monographs, issues of journals, offerings, rare editions, and more. And the thematic core of the collection is Byzantium. The subjects of the collection, however, vary. In general, it includes Byzantine law, of course, ecclesiastical law, religion, social topics, economy, medical issues, art, literature, history, and more. We will see other categories upstairs later. One of the things that makes the collection special is that it includes editions that currently are out of print. Also, it contains complete monographic series, and it should be noted that the collection includes some editions that cannot be found in other libraries in Athens. This provides researchers, scholars, and to anyone else interested with the opportunity to browse a rich collection of Byzantine culture. And here, as you see, there are some of the publications that are included in the collection and the name of some important authors that we have their works. The Institute wanted to honor the donator, so it decided to house the collection in a place separate from the main collection of the library and to name the collection after him. Moreover, NIA decided to add the acronyms TC, Troianos Collection, on the top of the call number and created a specific collection at the library's management system, OpenAbect, where the acronyms TC indicate a specific collection. Also, a separate seal was created especially for Troianos collection, and the seal can be found on the title page of its item. In May 2022, the NIA, in cooperation with the Legal History Department of the University of Groningen, organized a symposium on the occasion of the donation of Professor Troianos, as Daphne told us earlier, and we were really pleased that he was present and very much enjoyed the event. The latest action of NIA in order to honor the professor was the decision to establish a new series of Byzantine lectures, the one that we're here celebrating, Byzantine Talks NIA, thus providing a space and place where the new ideas will be discussed. And here you can see on your left the seal that was created. Next to it is the acronyms TC at the call number, and in the last picture down you can see the collection. We have selected the book, and you see if you put the mouse on it that says Troianos Collection, so it's easy to find it. Now, users of the library can either come in person and search for the book that they are interested in, or consult the library's online catalog through the link that you see. The search of the book can be done in multiple ways, either through the name of the author, the title of the book, or the subject, and it has many more choices. The library doesn't know books, but you are welcome to come and study here in the reading rooms that we have. The library's opening hours are weekdays, except Thursday, 9 until 4:30. And please, if you have any question that you want, you can either email me or call me so I can help you. And lastly, you see here the picture as the Troianos collection is ready now. And thank you for your attention. We will have the tour upstairs. And before we close, we want to thank Daphne for being here, Lydia Papariga for moderating the conversation and everything, our director for helping us with everyone, with everything. And as we said, we're starting a lot of events. So our next event of the library will be on October 9th, where we will have a book presentation of the writer Nikolou Smith, and the title of the book is Sabina in Athens, and it's related to the Actor and the Emperor, and Sabine is his wife. So we will be really glad if you could be here, and we'll give more information in the following months. Yes.
And one question. Is your library connected to the others? Is your library connected to the other academic libraries?
You mean we have the same catalog?
No. For searching.
Yes, the ones
the global system in Greece. We have all the academic libraries. We can search a book.
Yes, you mean the one that the Competition University you have?
Not only.
Well, the library has a certain system. So the one that ECHA does, it's a cooperation between specific universities. Through OpenVect, all the libraries that use the same system as us, of course, we are connected with them. That's the difference. The difference is the library system.
Okay.
Thank you. So, we can go upstairs. Thank you.